Hello, welcome. Dave Brannen here for another edition of Ask a Lawyer Live. Apologize, I've been away for such a time. We had the Canada Day. I was out on Monday for a medical procedure. Forgot about it to cancel the live stream. So, excuse me. So it's been probably almost a week since we've had an episode. Today I'm going to be talking about, there it is. What counts as a toxic workplace environment from a legal perspective? This gets thrown around a lot that my workplace is toxic or that it's a terrible workplace. But there is a legal standard out there for if your workplace qualifies as a toxic work environment from a legal perspective, and we'll talk about that. I'm also going to be talking about giving you an update on the Canada Disability Benefit. There was some new information that's come out, mostly around the appeal procedure, so it's maybe not so interesting, but we'll at least cover it so that you're aware that if you or someone you know gets denied benefits under the Canada Disability Benefit, you will have some knowledge of what the appeal procedures are and how you can go about that. Okay, first of all, let's dive into this. So this is an important topic about what counts as a toxic work environment from a legal perspective. I'm David Brannen, as you know, employment lawyer here at Resolute. I'll guide you through what your rights are dealing with workplace toxicity. And hopefully by the end of this presentation, you'll have a clear understanding of what the law says about toxic workplaces and steps you can take to protect yourself. So what exactly is a toxic work environment? First, let's clarify what we mean. Generally, people think of a toxic work environment as a place that's unpleasant or stressful. However, from a legal point of view, a toxic work environment specifically refers to conditions that are severe enough to violate employment laws or rights. It's crucial to recognize that legally actionable situations, because these can seriously impact your mental health. So when you have a legally actionable situation for employment toxicity, these are situations where it really can affect your mental health, your well-being, and job performance. Recognizing this distinction helps ensure that you can respond and protect your rights when you need to. So let's dive into this. Legal protections in Canada. So just so you know, when we're talking about toxic work environments, we're really talking about three areas of the law, and three areas of the law that protect people from toxic workplaces. These include Human Rights Acts, which these are provincial, and there's a federal one. They prohibit discrimination and harassment based on protected grounds of discrimination, such as age, gender, disability, sexual orientation, etc. Now, second, we have Occupational Health and Safety Acts. These laws require employers, and again, these are provincial laws, they require employers to ensure that workplaces are both physically and psychologically safe for workers. And finally, we have the area called constructive dismissal. This is part of the common law of Canada. This will apply in all provinces except Quebec. This principle applies when the workplace conditions become so intolerable. Apologize, I'm going to sneeze here. So intolerable that an employee feels forced to resign from their employment, essentially treating it as like you've been terminated from your employment, even though you technically have not been terminated. This is a very delicate area of the law. There's a lot of nuance there, so you want to be careful before quitting your job and calling it a constructive dismissal. Okay, So, signs that you may have a toxic work environment. So, a legally recognized toxic work environment includes behavior such as harassment, bullying, which could be physical or psychological. It could include discrimination based on some of these protected grounds of discrimination that I just mentioned, and any type of intimidation or threats, whether explicit or implied, that makes employees feel unsafe. It includes systemic exclusion of individuals, such as intentionally placing the employee apart from meetings and things like that. Now, just to understand that it it will not cover all situations. There was a famous court case in Ontario. I have it here to review. If I want to go to it here, let me just get the name. I forget the name off the top of my head. Oh yeah, the General Motors versus Johnson case. That is an important case. One of the leading cases on what constitutes a toxic work environment. Now, that case found that the individual Johnson did not have a toxic work environment, and it basically made the distinction between work environments where there may be elements of racism or bad behavior from something that would legally be set out as a toxic work environment. The court in that case emphasized that it is not the subjective feelings of the person. So a person can legitimately and in good faith believe that there is a toxic work environment, that they're being discriminated against, and that it is a systemic and ongoing situation. But the law will look at it from an objective point of view and not consider the person's own subjective beliefs, and will look at it to determine from an objective point of view, is the workplace toxic? So this is a legal distinction that a lot of times you will hear of, these objective versus subjective tests. They make it difficult, especially for people who do have a strongly held belief that the workplace is toxic. The focus is often on like the separation of a single incident versus repeated ongoing incidents that would be of a severe nature. Keep in mind that workplaces often have an element of discomfort, and the line between what is bullying and not bullying, that word gets thrown around quite loosely nowadays. There's a lot of behavior that falls short of bullying, including corrective actions and different supervision and feedback within a workplace that may be unpleasant but do not constitute bullying, even though a manager continues to follow up with you about the same things. That's not really bullying. It can fall under permissible managerial actions. So please just keep that in mind. Okay, let's go on here. Now, things that have been recognized by courts. So continuous verbal abuse is a big one, or shouting when it's done ongoing as part of a workplace culture could help this be determined to be a toxic workplace. Now, this would often need to be included with demeaning or other racist type statements or intimidation for it to fall under, to create an actual toxic work environment. Frequent discriminatory remarks or jokes that can create a hostile work environment, or also a toxic work environment. This is a tough one, but unjustified negative evaluations or disciplinary actions aimed at pressuring an employee into resignation. This is tough because, again, this has to meet an objective test. You may in your own mind, you may believe that you are getting unjustified negative performance reviews, but from an objective point of view, they may be seen as not unreasonable or unjustified. Okay, that's going to be where the difference often comes in. Another one would be intentionally giving someone an overwhelming workload in order to try to get them to quit or put unrealistic demands on them, that type of thing. That can also be signs of a toxic work environment that have been recognized by the courts. Now, just to touch on constructive dismissal, I've talked about this in other sessions. We won't go into great detail on this, but keep in mind that constructive dismissal is a legal concept, and it is a way that you can quit a job, essentially. You can quit your job and still sue for termination pay. Normally, when you quit your job, you are not allowed to sue for termination pay. but there is a legal exception, and that is constructive dismissal. So you have to, when a constructive dismissal situation, you quit your job, but you say that you had no choice but to do so. And one of for you and you have to cite one of several recognized grounds of constructive dismissal, and one of those grounds is that there was a toxic work environment that was not being remedied or fixed by the employer. All right. So if you're affected by a toxic work environment, it's important to act systematically. So you do want to have a process that you go through. It's very important to document everything, dates, times, details, etc. Note any witnesses who can support your account. Very, very important that you report incidents internally and go through the proper channels and follow through. You won't be determined to have a toxic work environment if you have not notified anyone or given the employer chance to fix the situation. So you do need to go through the internal process. You can also approach external agencies like the Human Rights Commission, or in some cases, occupational health and safety commissions of each province to report issues. And also, like, obviously, you can seek help from a lawyer to clarify, to see, is this going to be a situation where I can, like, certainly if you're ever considering a constructive dismissal and quitting, you really need to seek legal advice to determine, have you done enough to set the groundwork that you will be successful in a constructive dismissal. Sometimes people will quit their job and then come to us and say, I want to claim a constructive dismissal, but they didn't really lay the proper groundwork. They didn't approach the employer with concerns or suggest alternatives and these types of things that you want to see in a situation before trying to claim constructive dismissal. The danger with claiming constructive dismissal is that a court will find that there was no constructive dismissal and you just quit and you now don't have your job, you can't get EI, and you are not entitled to any termination pay because you were not terminated. So as far as employers, employers do have obligations to provide a safe and respectful workplace, and they do have a lot of legal liabilities if it's proven that they failed to uphold that. That includes giving compensation to workers who've been affected, and there's other financial penalties and fines and things like that. Most of the people watching this are not going to be employers; it's going to be employees, so it's not as important to know. But if you are an employer, it is important that you take these types of situations very seriously. You may have to hire outside investigators to do a proper investigation. It can get expensive, but you do have obligations to do investigations under the Occupational Health and Safety Acts of each province. All right. With that said, we'll dive into our question section of the I was going to say podcast, but it's not really a podcast, of the live stream here. So if you have some questions for me, just throw them in there and I'm happy to answer them. I'll keep an eye for those. In the meantime, I'm just going to have to blow my nose here, so I will mute so you don't blow you guys out. Sorry about that. I'm not sure if anyone else has seasonal allergies like I do, but seasonal allergies are really bothersome. Okay, so let's look at, while we're waiting to see if there's any questions, I am going to talk a bit about the Canada Disability Benefit. I'm going to share my screen. I got this email. I'll just share my screen to show you what it was. Here we go. So I got this email last week, June 25th, and it set out the new appeal process for the Canada Disability Benefit. I get these emails because I signed up for updates. So if any of you want these updates, you can go to the Canada Disability Benefit website and sign up for these updates. All right, so let's look at what we have here. I haven't even really gone through this yet, so we can kind of go through it together. And I do see some questions coming through, and we'll get to those in just a second. Let me just cover a little bit about this first. All right. So the appeal process looks like this. This is on the website of the, can't really see it well here, but this is the Social Security Tribunal website and the appeal for Canada Disability Benefits. There's 2 levels of appeal. So this is going to act exactly like a CPP disability appeal would. And what would happen is you would, but by the time you get to this point, you will have got a denial from Service Canada. You will do a reconsideration directly with Service Canada. And you will get a so you first appeal is actually right with Service Canada. It's called a reconsideration appeal. If that appeal is denied, you have 90 days for that appeal. If that appeal is denied, then you would come to the Social Security Tribunal. You do that by filing a notice of appeal with the tribunal. And then once you're there, this is the kind of process that you would go through. All right. Let's dive into some questions. I'm going to get into this. I'd rather do people's questions. So Lee has a question. Lee is asking, for those returning to work, how long can the transition process be? Can I go slow and take 3 to 6 months of time, then go to full time? And Lee also adds, what percentage of return to work succeed? Okay, so let's do the first question first, Lee, and then I'll go on to your second question. So for those returning to work, how long can it take? This will often be a complicated question, but it's usually the answer is you can take as long as you and your employer can agree to. And most employers are not going to push back too difficult on this because they know they have a legal duty to accommodate you. So from the employer's point of view, they're more likely to be accommodating and let you take a longer time to try to do this work, to back to work transition. However, if you're on long-term disability insurance, they are not as likely to give you a flexible longer time. Long-term disability insurance companies will typically just dictate a period of time and say, we're going to pay you for the next 2 months. And they don't care after that. If things are going slower, they don't care. Like, they'll just pay you for 2 months and they're done. So you can get yourself in a situation where you are not back to work full time, but the insurance company is saying, we're done. We think you should be able to be back to work full time. Your employer is still letting you do a slower return. And you can find yourself in that situation. Absolutely. Now, that's unfortunate. In that type of situation, you can appeal the insurance company's decision, but it's often impractical to and they know this, it's often impractical for you to do anything about it. Because if you are still working, you're not being paid full time because you're not back full time, the insurance has stopped kind of paying. Because what will happen, just to clarify, there will be a period of time where if you're working less than full hours, the insurance company will top you up when you're doing a return to work process. But if the insurance company puts an arbitrary deadline, if you have not gotten back to full-time work by then, they will just stop their payment. And so now you're just getting paid less. The insurance companies know that it is often impractical for you to do anything about it. You can appeal and they'll just deny the appeal. And you're left with a situation where you have to sue them over a partial payment that may only be for a few months. So what I typically tell people is, unfortunately, you just have to kind of figure out a way to make it work and see if and when you can get back to full-time work, then calculate how much money the insurance company owed you. And if you are certain that you are back to full-time work permanently, you've been back to full-time for more than 6 months type of thing, then you could consider going after the insurance company in small claims court for the amount that they might owe you. But when I often see these cases, what happens is the person never is able to get back to full-time work. They're left at a permanent part-time situation, or they kind of crash out after a few months and they're off again. So in both of those situations where people are left with a permanent part-time or they've crashed out and now have to go off work completely again, those are situations where we can sue the insurance company on your behalf. So it can be reasonable for just to go back to your question, it can be reasonable to take 3 to 6 months if your doctor thinks that that's appropriate and your employer agrees. But an insurance company will rarely agree to that long of a time frame. Maybe 3 months, but definitely not 6 months. So you would need to work closely with the insurance company. Not saying they will never agree to it, but it is usually they are going to just be very rigid and they will want to just put a deadline on it and stick with it. Now, Lee asks also, what percent of return to work succeed and how many return to work attempts normally needed before success? That is a very hard question to answer. I don't have the data on that. I really don't. I know personally, like they can be successful. We certainly interact with a lot of people who contact us for advice, and they do return to works and get back to work. Okay, so they can succeed. It really is. I don't have any data to be able to tell you what percentages would succeed. Honestly, a lot of the success is going to depend on, is your job the type of job that you can do on a part-time basis and allows you to get back in there. So a lot of it will be with how good the work environment is, whether you are actually close to being capable to getting back to your job. Where these will often fail is where there's a poor work environment and poor relations with the employer to begin with. The employers then will often sometimes sabotage the whole thing. So a lot of it is very specific to your situation and the relationship with your employer. And as far as how many attempts, again, this will depend, but typically, if you do one attempt to get back if you've been off work for quite a while and you do one attempt and can't get back with your employer, certainly you could try more return to work attempts with them, but at some point employers will try to terminate your employment based on frustration of contract. Not easy for them to do that. And a lot of this will depend just on your medical evidence and what your doctors are saying. All right, now we got Yusuf with some questions here. This one says, I've been off work for over 3 years due to discrimination, bullying, toxic work conditions that led to disability. I had 2 jobs, one over 49K and one 30K. I'm going through arbitration through my union. How much should I ask for in lost wages or damages? Should I ask for a full 3 years income? I have medical support. Any advice to prepare? Okay. Lost wages are a difficult one because, first of all, you can claim lost wages in theory, you can claim lost wages for the period in which you would have worked, but for the discrimination and bullying. Now, I don't know if you're also getting long-term disability or workers' compensation or anything like that. That is going to be an issue. So if you are getting long-term disability or workers' compensation, then there can be some clawbacks from if you get money for the same period of time that you've been getting those types of benefits. But yeah, in theory, you can claim the full lost wages, less any amounts that you may have to pay back for EI, or you may get clawed back money that you would have to pay to an insurance company or workers' compensation. So Yusuf's clarified he's on LTD. So yeah, you could claim the income, but remember, like any payment for lost income you would get from the arbitration, if it is designated as loss of income, depending on what your insurance policy says for long-term disability, they will be entitled to be recouped. So any months where this income is covered for your loss of income, that if you receive long-term disability in any of those months, you'd have to pay back the long-term disability. So what happens in practice is you get an amount of money paid out of the arbitration, then you would have to pay a large portion of that back to the insurance company. And if you don't do that and the insurance company finds out later on, they will cut off your benefits and kind of sue you for the money, that kind of thing. Again, it will depend on the wording of your policy, your insurance policy, and the money and how it's designated. Now, if there has been bullying, discrimination, certainly any money that's designated as human rights compensation, not for loss of income, but for compensation for like pain and suffering, that kind of thing, that is not subject to being offset by the long-term disability insurance. Is not taxable or anything like that. So to the extent that's possible, you will want to claim those types of damages and have that have the money designated as that. Now it has to be reasonable. So you can't say that it's all that necessarily. There may have to be some component that is designated as taxable termination pay or loss of income. Um, I can't tell you directly what you should claim, Yusuf, because I'm not your lawyer. Number one, I don't have enough information about your case. I can only tell you that in theory, you can claim loss of income for any period of time that you've been out of work because of the discrimination. So the way it works is that if there was discrimination that led to you being off of work, then in theory means that doesn't mean it will happen in practice, but in theory, you can claim loss of income from the point where you would have earned income here, but for the discrimination and this type of thing. But yours is a complicated case, so I can't really give you a specific advice. There's a lot going on here, and I don't know what province you're in. Certainly, the types of things you're talking about might be covered by workers' compensation or should have been. Like, there's so many different angles here that I unfortunately can't give you specific advice. So your question is, how do you fight bullying and discrimination? To fight bullying and discrimination in arbitration, you must have evidence to prove that there was discrimination. Part of that can be your own accounts of things, but often you're going to need more than that. Like if there's anything in writing that you have to show that there was discrimination, ideally you would have some type of witness who could confirm like your point of view of what happened. If it just comes down to you saying one thing and whoever the bullying person is said the other thing, then that can be a problem. Now, a lot of these I would expect in your situation, I don't know for a fact, but there could have been a workplace investigation. So a lot of the information can come from that to either support or refute what you're saying. But normally there would be a workplace investigation into your complaints, and that investigation will either be helpful or hurtful to you, and you may need to challenge that investigation if it's not helpful to you. Now, if you are in a union, you should have representation. So talk to the union. They may have lawyers hired to help. You should be talking well in advance of the arbitration to talk about what are the kind of things that we need to prove, what evidence do I need to bring, because you can have a situation where this legitimately happened, but you're not able to prove it. Excuse me. All right, Lee's got a question. Again, Lee's saying, what if I return to work, but the quality of my work and ability is poor and my managers are unhappy? What would I do in that case? This is my worry. Okay. So your employer will have an obligation to try to accommodate your disability to the point of undue hardship. That is a very difficult area to say what is hardship, what is not. A lot of it will depend on the employer. But if you are not capable of doing the job, then you're not capable of doing the job. They can try to make accommodations to help you do the job, but ultimately, if your work is too poor and does not meet certain standards, then you would be deemed not capable of doing that job. Your employer would be able to dismiss you from employment for not being able to do the job. The employer may have maybe there's more suitable other alternative work that you could do. They don't have to offer other work. They just have an obligation to try to accommodate you into the job that you had. So, but if you're not capable of doing the work, then unfortunately you're not capable of doing it. Now, depending on where you are with your insurance policy, if you're still within the first 2 years, then if it's determined you can't do the work, you could go back on LTD. But if you're to the point where the LTD only covers you for any occupation, then it gets more complicated. You may not be able to do this job, but you'd also have to prove whether you could do other work or not do other work. So if things would not work out with this employer where you can't meet the standards necessary, even with accommodations, then you would have to try to look at other alternative jobs and determine if you could find other work where you could earn an income high enough to meet the threshold of not qualifying for disability benefits. So you would have to try to find other work that would have comparable income to what you were getting on, at least what you were getting on long-term disability benefits. If you, maybe even a little bit higher, but if you're not capable of doing that level of work, then you may still be qualified for long-term disability benefits. Depending on your policy, how it's worded, there might be a situation where you might be able to do some level of work, and the insurance company would have to, in theory, again, have to top up your payments. Insurance companies in practice, they do not like a situation where someone is working in some other occupation part-time and getting a top-up payments. They often will not agree to that type of situation. So they will force you into either working full-time, and if you're just not capable of that, then you're in a situation where you might have to sue the insurance company at some point, because they will allege that you can work more than what you are. Okay. Mania, who is a regular, has a question here. It says, for anxiety and depression, would CBT, cognitive behavioral treatment, online group therapy be accepted by insurance if the doctor leading the group is renowned Australian psychiatrist and author? Yeah, I would think so. I don't know what you mean by accepted by insurance. Do you mean like would they pay for it, or would they accept it as evidence of disability, that kind of thing? Any treatment that is by a psychiatrist, I think, even if they're Australian, like the standards of medical care between Canada and Australia are close enough. So unless this doctor was so far out of the mainstream, then I think an insurance company would take it for what it is. Yeah. I think in many clarify, would they accept it as evidence? I think they would. Yeah. They may not agree with it. Like, even if they accept that, yeah, this is a doctor doing appropriate treatment, they still may conclude that they don't think you're disabled, right? But I think it would be acceptable evidence. Yes. Yeah, because CBT is recognized. And this is a psychiatrist, so the fact that the psychiatrist is out of Canada is not that important to me, because the standards between Australia and Canada are close enough that I think that's fine. Like, I have lots of clients who have doctors in the US, and there's never an issue with that. Australia is not that different in terms of what you could expect for medical care and standards. Yusuf has another question. Does CPP disability allow a person to travel? The answer to that is yes. I want to travel to do some therapy in another country, as I can't find it here in Canada, even if the insurance won't, but they can't find any here where, okay. So definitely CPP disability doesn't care if people travel. All they care about is that you continue to be under care as needed, and that they can get a hold of you if they need to. So they have to be able to get in touch with you if they need to. If you're traveling out of country, just make sure someone's monitoring your mail and phone if Service Canada is trying to get a hold of you for whatever reason. I've seen people leave the country and CPP disability is not able to get in touch with them, and they will eventually just cut off your benefits. Okay. I had a famous situation where a person left their spouse to go with another person traveling the country while on CPP disability. So they got in a romantic relationship and left their spouse and then left, but didn't change their address. So all the mail kept going to the disgruntled ex-spouse. So that ex-spouse was reporting them as a fraud and all this stuff, and not telling them that there was any communication. So eventually that person's benefits just got cut off, and they called us saying, "Oh, my benefits got cut off." And I was like, "Well, did you get any communications?" "No, we didn't. I didn't hear anything." But then I find out they're living kind of in a Winnebago, driving around. I was like, "Well, of course. Like, what do you expect?" Like, they have to be able to get in touch with you. I've had other situations with people going to Florida and just nobody monitoring the mail in Canada, and then getting into a lot of problems with Service Canada because they're not responding to if you don't respond to a couple letters, then they can take actions like that. All right. This is from Geofly. This is welcome. I think this is a new person. Don't think I've seen you ask a question here before, and I thank you very much. It says, I'm 53, medically retired, and have been on LTD for 5 years. CPPD recently denied my first application due to my disabilities being well controlled. Okay. So next steps would just simply be to appeal. If you've just been denied your application, then you have 90 days to do your reconsideration appeal. You should do that right away. There's not a need to, you can do the reconsideration appeal in 2 steps. So what I recommend people do is just put in writing to them that you want to appeal and that further documents will follow. That way you get in your notice. It's very important that you give them the notice of appeal within 90 days. Once you give the notice, then you've met the deadline, and you can then take longer to get them more information to support your claim. So that's what I would recommend. Then you can have as much time as needed to get information to support the claim. I guess what I would do too is if they're saying your disability is being well controlled, I don't know really what they mean by that. Just because something's well controlled doesn't mean that it's not disabling. So you may want to make that distinction for them. You might want to get your doctor to write something to indicate that while you're on a steady medications, there's no changes, you're not in active treatment, that your disability is stable. You still have a disability that would prevent you from working. That's where you'd have to go with it. The fact that you're on approved long-term disability, that doesn't necessarily mean that you would also qualify for Canada Pension Disability automatically, because long-term disability can pay people who even have a capacity to work. So that wouldn't automatically mean that you get it, but I would encourage you just to do the appeals. And your insurance company, if you're on an approved long-term disability, you should actually contact your insurance and ask them if they can pay to have if they can pay to get an advocate to work with you. We don't do that type of work with insurance companies, but there are advocacy groups some of them are quite good, who do work with insurance companies to represent the insurance company's long-term disability people in appeals of CPP disability. This is in the insurance company's best interest, in their financial interest, because if you get approved for CPP disability, it means less money they have to pay you. It's also in your interest to get CPP disability because it can greatly improve the amount of money you will get at age 65 when you get your Canada Pension retirement. So there's a big incentive that you really should try to get on CPP disability, and start by exploring with your insurance company. Do they have someone that can represent you in the reconsideration appeal? Or if you're unsuccessful in the reconsideration appeal, then you would go to the Social Security Tribunal. And certainly that is when I don't know if the insurance companies help people at the reconsideration level or if you have to get to the tribunal level. I don't know, but you could check with your insurer. Great questions. Anyone else have anything? You're welcome. You are welcome. Okay, let's go back to this for a second. So this is a page you can always go back to if you want. This is the Canada Disability, the official page, at the government of Canada for the Canada Disability Benefit. You can see they keep adding things. So this is new. How much could you receive? Do you qualify? How to apply? After you apply, this is new. So this is a new section. I haven't seen this before. Waiting for a decision. Looks like 28 days. That's pretty fast compared to CPP disabilities, like 4 to 6 months. Yeah, 28 days is quite fast. If you disagree with an eligibility decision, payment amount, or area. Oh, reconsideration is 180 days. Wow, that is a lot longer. Normally it's 90 days. They've extended this. So you have 180 days to submit your reconsideration of a denied Canada Disability Benefit. That's interesting. That's a lot longer. That's like double the time. And if you miss the 180 days, you'd have to explain why you couldn't submit it sooner. So you have to request a reconsideration. If you get denied, this is the same process as with CPP disability. So just so GeoFly, it's the same kind of, it's the same type of product. You don't have 180 days for CPP disability. You only got 90 days, but interesting. If your request for reconsideration is denied, that just means when you ask the reconsideration, they will do a reconsideration. So I don't like if your request for reconsideration is denied. So they're not going to deny your request. They're going to say, we've reconsidered it. This would be better to say, if your reconsideration is denied, then you would go to the Social Security Tribunal after that. Interesting. Overpayments. Uh-oh. Yeah. Okay. So there could be overpayments. An overpayment could happen if your taxes don't accurately reflect what your income is, and maybe you should have got a lesser payment than you did. I think that's probably one of the ways an overpayment is going to happen here. If your taxes get reassessed, because they're going to base your payment amount based on last year's taxes on your taxable income. Interesting. Okay. Interesting. They keep building this thing out. There's an estimator here that you could use. All right. There were some other things. I think that's pretty much what I wanted to cover today. So it's a short week. I won't be back. I'm going to be off again tomorrow. I'm not going to be doing a session here tomorrow or Friday. I'll be back next Monday. But if people have questions in the meantime, you can always email us, or just come here with your questions. I'm not sure what I'll be covering next week, but you'll just watch your email. Jen will email out what the topics. She picks the topics, not me. So I'll find out, just like you, what the topics are going to be next week. So just wait for Jen to send that out. You'll see. But hope you guys are having a good summer so far. We'll see you back here next Monday. I wish you all the best. Take care.